Hello everyone, my name is Dan Rollins and I'm the Director of the Health Labor Relations Office here at UC San Diego Health and Health Sciences. We're here today to talk about the very exciting topic of labor relations and labor law. Hopefully you won't fall asleep in the next 5 or 6 minutes that we're going to talk about just this brief overview, but we do want to highlight a couple of different things throughout this presentation that we hope that you will find interesting, and then also talk about some in-depth opportunities that we have later on. Generally speaking, you as a new manager may or may not be familiar with a unionized environment, and that's okay. Here at UC San Diego Health and Health Sciences, we have roughly 80 to 85% of our workforce is represented by a union, and that covers anywhere from 14, 15, or even 16 different unions throughout the UC environment, many of which are system-wide and several are local only. However, for today's purposes, we're going to talk at a very high level just about what labor relations does and then how we would most commonly interact with you in your capacity as a new supervisor or manager to the environment. So, generally speaking, we have 5 broad categories. First of all, the direct interaction with unions is the most common and easily understood. Our job in labor relations is to administer grievances and arbitrations, issue notices to the union about changes in the work environment, process requests for information, and also engage in bargaining. Similarly, we provide guidance to management with regard to contract interpretation. We facilitate labor management meetings and mediations in general between both you and the union. We also advise the enterprise, so to speak, for how the contract is meant to be applied, generally speaking, i.e. contract clarification. That applies both to you and to the employees, depending on who the caller is, and we are there as a resource as anyone needs us. The fourth area that we commonly find is the participation in administrative litigation, arbitration, and mediations as they relate to grievances or formal filings by current or former employees. Some of the areas that we deal with most frequently, the EEOC, the Equal Employment Opportunity Commission, the DFEH, the Department of Fair Employment and Housing, or PERB, the Public Employment Relations or Resources Board. That board, PERB, is responsible for administering the law that governs the relationship between a public employer and a public union under the Higher Education Employee Relations Act, otherwise known as HERA. Generally speaking, you won't be involved with too many of those, so you don't have to worry about it too much. And then the last broad category is in regard to coordinating of all elements related to a work stoppage, otherwise known as a strike. The Labor Relations Department is one of the key areas to coordinate and corral all of the different cats of the UC enterprise when there is a strike. Thankfully, there aren't too many. We are almost closed with all of the existing contracts as of late 2019. So if you're seeing this now, you should have a couple of years where we're not going to have any strikes, which is good news. We do work with the Hospital Operations Committee controlled by the Chief Operating Officer, as well as Talent Acquisition and HR to help you, the department, plan for that strike event and get all of the necessary replacement staff as appropriate. Thankfully, again, we don't have too many of these, so we're not going to worry about them unless you hear from my department directly. Now, the most common interaction that we have with management is between the unions through the grievance process. I'm going to cover very, very quickly what that process is. And the reason why we cover it so quickly is because we have a specialty clinic. It takes about 90 minutes, and we strongly encourage you to schedule that with our department. In the interim time, let's talk about the grievance process. The typical grievance process is a multi-step process whereby the union files a grievance. We have a series of steps, as you can see behind me. There's multiple steps in the process before we would get to an arbitration, and that typically takes about 60 to 90 days to go through this entire step 1 through 3 process. Again, this is a high-level overview, so I don't want to bog you down, but I will point out that you should be familiar with the contracts that govern your staff. And you don't need to be an expert, but you should be at least commonly aware of what the scheduling requirements are, what the seniority requirements are, and then any other specialty elements about certification pay or education leave, things of that nature. And when in doubt, reach out. Call my office and we'll be able to answer that question for you. Now, within the grievance process, the union plays a role, management plays a role, labor relations plays a role. We're not going to cover it now because we do offer that specialty training, but as you can see in the supplemental materials, there are specifically defined roles and functions for each of those 3 parties. Now, one element that I will highlight, it is not the union's role to interrogate or depose you as a management rep. Your job is to be a neutral reviewer of the facts. Their job is to present evidence, and if it gets unruly, labor relations personnel are very well versed in putting a stop to that meeting and exiting right then and there. So we have your back in that regard. Now, one question that we frequently get, especially for those who are new to a unionized environment: do the unions and the union reps have a right to be in the workplace? Absolutely. The unions are protected by laws that allow them to have access to the workplace to provide inspections, to meet with their members, to conduct investigations, and a variety of different things. However, the access is not generic and is not all-powerful. The access must be reasonable, must comply with the contracts, and must comply with local rules. Additionally, there's a couple of broad areas. Number one, the union here at San Diego, all of the unions here at UC San Diego Health and Health Sciences, are required to alert labor relations in advance of any planned arrival into the work environment. Or, if it is an unplanned event, they must check in with you, the manager, upon arrival to your unit to alert you to the fact that they are there. And it's important to remember that they are not allowed to engage with employees who are working around the clock, because that's our time as the employer, and they are not allowed to linger in patient care areas. That is a protected area that is designed to be a sacrosanct healing environment for patients and their families and or visitors, so unions are generally not allowed to be there. However, they are allowed to meet with employees within the break rooms, as long as those break rooms are not otherwise a secured area. So again, similar to the grievance process, we have a very detailed, in-depth presentation and training on this. This takes also about 20 minutes. It is highly interactive with a lot of hypotheticals and is generally one of the better trainings that Labor Relations provides. So we would strongly encourage you to reach out after you've gotten through all of the initial training and schedule that with us. The last item that we would like to talk about is the HHR website. If you're not familiar with it, you need to go familiarize yourself with the Health Human Resources interactive website. It allows you to initiate a case with each of the individual subunits, and it can be used not just for labor relations, but any of the tasks that you would need to do, both as an employee and as a manager. Specifically, you can look to schedule a training, or you can submit a case and have that question be answered electronically. So we highly encourage everyone to go there, familiarize yourself with that area, and use it to your advantage throughout your time as a manager. Thank you very much.